Well, hello everyone, and welcome to Uncivil Law. For today's story, we're doing a live stream where we are going to look at John Hopkins' appeal brief in the Take Care of Maya case. As you will recall, Johns Hopkins was the hospital that, in which Maya was present. I was going to say treated Maya, and then I thought the better of it. It's like, no, that's not quite the right phrasing. In which Maya was present and did things that were questionable at best at times, and a jury awarded a fairly substantial award for the bad things that they did, possibly in excessive law, and also possibly because one of the theories, the major theories, for which half the damages were awarded may not necessarily be legally viable on this intentional infliction of emotional distress claim leading to the death of the mother. May not necessarily be legally viable. And we've discussed this before. So I have questions. So first of all, if the intentional infliction for the emotional distress of the mother disappears, then about half the damages disappear. So $100 million goes away. So that's a good day for Johns Hopkins, right? Instead of $200 million, how about $100 million? I mean, hey, that's still better. And then some of the other actions are, also a little bit questionable at times. So it'll be really interesting to see what the court are going to do with this. And I think the odds of this winding up the Florida Supreme Court on some of this are pretty decent because there's some potentially novel issues of law, which is always a really good reason when you wind up at the state Supreme Court someday. But we have to get through the Court of Appeals first before we can wind up to the state Supreme Court. So we're going to do that. We pick up their appeal brief on page 60 out of 124. The first 60 pages were basically a factual recitation of the case and some precedent, and just basic 60 pages worth of background. I mean, there was a lot of it, so fair. But we're going to skip the background section and we're going to get into the argument section. So let's go ahead and do that. We pick up with the trial court erred in denying summary judgment and pre and post verdict motions for directed verdict. In other words, how about we just win on the intentional infliction of emotional distress and wrongful death claim for Mrs. Kowalski, which I'm not surprised they are starting with this argument, both because I think it is legally their best argument and also because it is the biggest bulk of damages. So, that is the logical place to start because, that seems logical. All right, great. The wrongful death was $60 million out of the $209 million, including punitives. I don't know, man. You might want to double check on that one. Plaintiffs claim that J-Hatch healthcare providers intentionally or recklessly cause Kowalski severe emotional distress damage to drive her to commit the self-harm. They allege that J-Hatch acted without good faith of potential abuse, executing a harassment and intimidation campaign to push Beata to the brink and destroy her relationship with Maya and her husband. Yes, but was the $60 million including punitives, or was that just the, because when I was saying half, I was including both liability and punitives. That was my question. So when you said 60 million, I'm like, is that 60 million just in liability, or did you also include the punitives in that number? So they were talking about the same thing. The 60 million was purely compensatory, was it? Okay, maybe you're right. Maybe my memory is off. Okay, 60 million. So a third of it then. Noted. Pressing on. But trial produced no evidence that J-Hatch's employees, individually or collectively, engaged in atrocious conduct utterly intolerable in a civilized community, which is the threshold requirement for IID, it certainly is, nor the evidence of trial show any intent to cause, which is the intentional, of emotional distress, stress so substantial or enduring no reasonable person in civilized society should be expected to endure it. That's correct. The overwhelming weight and authority holds that self-deletion is nearly always new and intervening cause that breaks causal connection. Yep, it certainly does. That is definitely the state of the law as it exists. That is true. And that is why I'm like, yep, this seems like questionable. Successful wrongful death claims premised on IIAD causing self-harm are so rare, in fact, this court will be the first in the country to consider the necessary proof for such claims after jury verdict. I believe it. I believe it. This may be nationwide novel, right? After a jury verdict. So there might have been claims that have been made before. There may have been judgments or settlements based on these claims, but this might be, in fact, the first time in the nation's history, or close to it, that we are going to decide this after a jury's verdict. and therefore there's a basis to appeal. So this might be a nationwide novel, not just Florida novel, nationwide novel. That's how rare this is. So yeah, I believe it. On this question of first impression, in Florida, certainly, I'm sure. First impression just basically means this is the first time anyone's ever asked this legal issue, and I agree. J. Hatch submits the foreseeability necessary to support the controversial liability theory requires proof of actual intent to cause the self-harm or some level of stress more severe than what a non-suicide IIED would require. Which, you know, fair enough, because it's the first time anyone's ever done it ever. So, like, even what is the standard we're trying to meet? Assuming this is possible in the first place, what is the threshold? Because we're making it up as we go along. Yeah. Courts have considered the issue pre-trial, recognized only two exceptions to the rule. Absent special duty. Self-harm is an intervening act when truly outrageous harm causes the decedent to experience an irresistible impulse for self-harm, or there was a substantial cause. Plaintiff evidence could not meet either exception. The jury said they did. I'm not sure whether a matter of law that's true or not, but we'll get there one step at a time. Yeah, we did look up that one case from 1890. Yeah, that was a good one, Tony. When we chased this down previously on a previous stream, and we rabbit holed this all the way down to ground, so that because we found a case in this case, right? That I think it was J. Hatch or one of them cited, and we chased it all the way down to ground, which is always fun. Like as you play the game of telephone, you find the case that cites the case that cites the case that cites the case, right? And so we chased it through like 3 or 4 citations, and we wound up in the California Supreme Court from like 1890 on a self-deletion that resulted in a damages claim to against somebody else. So insofar as there's precedent, we've got precedent from 1890 from the California Supreme Court that we are now game of telephoning trying to apply this in 2024 in Florida, which, you know, that's kind of how common law works sometimes, right? It's like, yep, that's what we're doing. We're citing a case from 1895 or whatever it is, and now that's the case we're going to go with. That's exactly what we're doing. You know it. All right, let's press on. Courts have considered the issue pre-trial okay, we read that. Without evidence supporting the claim relating to Mrs. Kowalski, the court should reverse judgment on these counts and remand with instruction. Fair. Standard review, denials of motion for summary judgment, directed verdict, and JNOV are all reviewed de novo because they're pure questions of law. Like the whole premise is we win no matter what they say. That's a question of law. Doesn't matter what the facts are, we win. That's the whole point. A directed verdict should be granted when no proper view of the evidence could sustain a verdict. Correct. No reasonable jury, as they say sometimes. Plaintiff never presented evidence either at summary judgment or at trial that J. Hatch's employees, individually or collectively, engaged in conduct outrageous enough to support the IIED judgment. Florida law sets a very high bar for IIED, which generally speaking is true generally. It is a somewhat disfavored cause of action, all things being considered, because we don't want to allow lawful or proper speech, even if the speech is vile, to be suable. So we do want to protect freedom of speech. So it is a somewhat disfavored cause of action, all things being considered. NIED, negligent infliction of emotional distress, is a little bit easier. So if this were NIED, negligent infliction, it'd be a little bit easier, but that got dismissed by the judge, and I think properly so. So all that's left is intentional, which is a somewhat disfavored tort. Plaintiffs must prove defendant's conduct was intended to cause distress or recklessly disregard the likelihood, exceeds all possible bounds of decency, and was regarded as shocking, atrocious, and utterly intolerable in a civilized community and cause severe emotional distress. Citing some Florida case, not that it really matters that much, because that's basically the correct statement of the law everywhere to varying degrees. That's basically correct. Severe emotional distress means emotional distress of such substantial quality or enduring quality that no reasonable person in a civilized society should be expected to endure it. That's basically right. The standard for outrageous conduct is particularly high in Florida. It is not enough that defendant has intentionally caused distress, acted with malice or criminal intent, or the conduct would entitle plaintiff to punitive damages. Fair, because this is a cause of action unto itself, right? So whether or not it would be a basis for punitive damages for some other cause of action, right? If this is a cause of action unto itself, then we must prove liability, right? We can't even get to punitive damages before we get to liability. Punitive damages on what? So you have to have liability first. So yes, I agree. Even extremely reprehensible conduct can fall short of the degree of outrageous and atrocious conduct required to sustain the IID. I agree. Only where the conduct is so outrageous in character and so extreme in degree and goes beyond all possible bounds of decency as to be regarded as atrocious and utterly intolerable can it sustain. Citing restatement. Yeah, this language, by the way, you should definitely be getting the impression from this language that this is going to be difficult to prove because it is disfavored. So yes, this is correct. We don't want to turn every insult into a cause of action. It requires something truly beyond the pale, which of course is not necessarily determined by its outcome, right? Just because bad things happen doesn't mean the action itself was beyond the pale. So the fact that she wound up self-deleting isn't good, but it doesn't mean that the action itself was reprehensible. The result might be reprehensible, but the action, well, that's debatable. Whether conduct is sufficient of outrage to support IAD is a question of law. How much do you need is a question of law. Of course it is. And the outrageousness of the conduct must be viewed objectively, not by the affected person's subjective feelings. Correct. We do this by the reasonable man test. As a typical rule. Fair. Only if the court finds as a matter of law the conduct is objectively outrageous enough can the case go to the jury. Yes, it has to be something that would, that's not tolerable by society, right? It's not tolerable by society. So while, the idea of the eggshell skull is something that we talk about sometimes, this is not one of those times. This is... Although even then, the eggshell skull is about the damages that result, not about the underlying liability. So you're responsible. The whole point of the eggshell skull idea is that if a person is particularly weak, you're responsible for the damage you cause, but you still have to be liable for the damage. If you're not liable for the damage, then how much they're hurt is irrelevant because you're not responsible, right? So we still have to get to the objective threshold of, did you do enough of a bad for this person to recover? They might have been really hurt, but is it the kind of thing society as a whole is going to recognize? Because, of course, there's a policy judgment built into it. Plaintiffs never clearly articulated which conduct supports the IID claim. They don't necessarily need to. The jury just needs to find it. Responding to Jay Hatch's motion for directed verdict, plaintiffs point to Miss Beatty's interrupting Maya's phone calls with her mother while monitoring calls under a sheltering order, not delivering a Christmas dress to Maya, asking Mr. Kowalski if he ever considered divorcing Miss Kowalski, not great, telling Maya that her mother was in a mental institution, also not great, and that Miss Beata could be Maya's mother, and photographing Maya to document her skin condition, which are all really, really bad things, but not necessarily really, really bad things we did to Maya's mother. See, that's kind of the problem, at least partially. It's like, okay, we asked Mr. Kowalski if he ever considered divorcing Maya, divorcing Maya's mother. Was that cool of us to do? Maybe not, but we did it to Mr. Kowalski. So if there's a cause of action, it's Mr. Kowalski's cause of action. Telling Maya her mother was in a mental institution. Is that a good thing to do? Probably not, but we did it to Maya, not Maya's mother. Photographing Maya to document her skin condition. Is that good? Maybe it's not, but we did it to Maya's mother. So what did we do to Maya's mother is a bit of a problem here. In closing, plaintiff's argument that the evidence of Jay Hatch's outrageous conduct towards Miss Kowalski was changing Maya's diagnosis, bringing Dr. Sally Smith into the case, telling Kowalski's that Maya could not leave the hospital, all of which were done in child abuse investigation and dependency court proceedings. But none of the 8 allegations rise to the level of extreme and outrageous conduct that's beyond all bounds of decency and utterly intolerable in the civilized community. Plaintiff's inability to prove such conduct dooms their claim. Yeah, this is This is not a bad idea. I'm not sure this is necessarily the strongest idea, but this could get somewhere. The problem here, of course, is like, what is the conduct is a bit of a question of fact for the jury. And so I'm not sure the legal causation is more interesting than the factual basis. The legal causation is more interesting to me, but this could work, I guess. Plaintiffs cannot alter objective reality by arguing that J. Hatch kidnapped and tortured Maya, or subjectively considering J. Hatch's conduct outrageous. The prior courts rejected a father's IIED claim against a daughter's stepfather based on allegations of kidnapping and interfering with the parent-child relationship. The father wildly exaggerated the stepfather's conduct, the court said, and even if the father subjectively considered it kidnapping, courts do not focus on the subjective response to the conduct. That's true. We're going to look to what the conduct is, not your perception of it. The reasonable man test, because we're looking for what society is or is not prepared to recognize. When viewed objectively, the court held the stepfather's conduct was nowhere near the level of outrageous conduct. J. Hatch's conduct in this case bears no resemblance to conduct found to be outrageous enough to send IIED claim to a jury. Conduct such as an insurance company intentionally denying approval of a claim to hasten her demise. That was a nice one. That was a nice one in the precedent, where the insurance company purposefully delayed approval of the lung transplant, not because they thought maybe it wasn't medically necessary, not because they thought that it was medically imprudent, or for some other medical reason, or at least in their view, right? They did it specifically and explicitly for the purpose of getting her to die faster. Our motivation was we hope the patient dies faster. That was a great case of the history. A creditor lying about debtor children being in a serious car accident as a collection tactic. That's rough. You owe us money. I'm not going to give you money. Oh my God, your kids have been injured. They need money right now. Oh my God, let me get the money together and give it to you. Yeah, that's not great. Or a cemetery disinterring a late husband against the wife's wishes and shipping the body to another state. Again, that's not great. I don't want you to dig up my wife's body. Too bad. Also, we're shipping it overstate. See, this is not good. Even if conduct were outrageous and intentional, it cannot support IID because Chapter 39 authorized much of it, and J. Hatch was acting within its legal rights. I don't know that that's true, but we'll give it a shot. Conduct that otherwise might be considered extreme and outrageous, even where substantially certain to cause serious emotional distress, cannot support IID where it's within a defendant's legal rights or duties. That much is true. Like, it can't be IID if it is legal, because that would be really dumb, right? So if it's explicitly authorized some other way, then it's not IID. Yeah. In a prior case, this defendant insurance company stopped paying for around-the-clock nursing care after plan failed to comply with the policy regarding proof of Medicare ineligibility. So it's like, well, we're not going to keep doing the care because you haven't proved that you're eligible for it, which is a whole different thing, right? We'd like to get paid. That's a whole different thing. We're not doing it out of malice or hate. We're doing it because we want to get paid. This prompted the wife's transfer into a nursing facility where she soon died. Because the insurance company had the right to discontinue payment, absent proof of eligibility, the conduct could not support IID. In other words, she couldn't pay for it, so they stopped providing care. Welcome to the American healthcare system. But it was legal, so The tragic results and defendant's conduct in reckless disregard do not matter for IID, even if the jurors found it to be atrocious. And then they also cite a case in which a store owner had a 6-year-old arrested for stealing gum. He had a right to at least ask the police to arrest the 6-year-old. Should the police have arrested the 6-year-old? I don't know. But, a piece of property was stolen from him, so he has a right to complain about it. So, that can't support IID. Here, J. Hatch was acting within its legal rights and fulfilling legal obligations under Chapter 39 and the sheltering order. Okay. I'm not sure you're going to be able to squeeze all this within Chapter 39. I know you've tried to do that before, but that's going to be a tough sell to squeeze all this within Chapter 39. Chapter 39 is basically, we think that there is an abuse problem, and we're trying to solve the abuse problem. That's Chapter 39, basically, right? So it's like, okay, we think the parents are being abusive, we're trying to solve the problem. There's obviously legal mechanisms there, including mechanisms that allow you to do things over the objection of the parents, but there is a legal mechanism to do it within the bounds of a rule. And J. Hatch kind of went beyond the rule, I think. J. Hatch could not return Maya to her mother and was obligated to enforce the court order restricting Maya Kowalski's contact with Maya. That's kind of true, but also kind of not, because part of the order itself required Maya to have contact with her mother, and you interrupted the court order. So you can't hide behind the court order when the court order itself tells you, hey, by the way, she's entitled to calls with her mother, and then you interrupt and monitor them. You can't hide behind the court order when the court order doesn't allow you to do the thing. That is not how that works. It is not a roll your own adventure, man. Okay? Maybe the court order is an error. Maybe the court order is an error. Maybe it's not. Maybe the court shouldn't have done that. Maybe that's a bad thing to do. But, you know, you are protected by the court order, but you're only protected by the court order. You got to stay within the bounds, man. You can't just freewheel this thing. Although plaintiff argues that as in Metro Life, defendant's conduct had tragic results, that itself cannot support the claim. I agree, that's true. The results itself cannot support the claim. That much is true. Because none of the alleged conduct clears the IID, jurors should never consider it. I don't know about that, man. I don't know. Yeah, I think that they did things that are arguably IID, including arguably to Maya's mother, even via proxy. And trying to squeeze this all into Chapter 39 is a tough sell. I don't think that the court, including the Supreme Court of Florida, is going to go out of their way to massively extend the scope of 39 under these facts. So trying to squeeze this into 39, trying to squeeze this all within the order, yeah, I don't know, man. So the question is even assuming that I could get rid of some of this stuff, which may be, but even if some of the stuff, is there enough left for a reasonable jury to find that there was outrageous conduct that was directed even by proxy, perhaps, at Maya's mother? Yeah, I don't think that's the most likely basis to win the appeal, but you know, you can try. No evidence shows that they acted with intent to cause the distress. Okay, because the estate failed to prove the outrageous conduct, the court needed to go no further. I think we need to go further. But plaintiffs also failed to establish the intent to cause emotional distress or acted with reckless disregard for her emotional distress. Plaintiffs alleged that J. Hatch's outrageous conduct was retaliation for Miss Kowalski asking pointed questions and taking down names when Maya was in the ICU. That was one of the things. It's not the only thing. According to plaintiff, Maya's providers panicked when Miss Kowalski questioned them and decided they weren't going to let this brusque lady with the Eastern European accent come in and tell them how to do their job. So they plotted to falsely accuse her of child abuse and intentionally mistreated her daughter to keep the pressure on Miss Kowalski and ultimately push her to the edge. Plaintiffs imagine that because Miss Kowalski asked too many questions, J. Hatch launched a month-long hospital-wide conspiracy to abuse Maya and drive the mother to self-harm. You see, the thing is, like, this is a slight mistake, or they're hoping that you will make a slight mistake in reasoning, because conspiracies don't necessarily have to be explicit, and they don't necessarily have to be something that's, you know, planned out in advance, you know, on the cork board with the, you know, 3x5 cards and the clips from the newspaper and the string with the push pins, right? So conspiracies obviously can take that form, but they don't necessarily need to. All you need for conspiracy is people acting in concert towards an illicit end, right? You just need the agreement and the actions towards the agreement. That's all you really need. And so, was this a conspiracy that was planned out? No, not probably. Was this something where people were on a track and pursuing things with a particular momentum because they couldn't see, you know, their head was shoved so far up their ass, they couldn't see anything but their butthole? Yeah, probably. So they make a slight mistake here by saying, oh, you think this was some sort of elaborate, drawn-out conspiracy. No, not necessarily, nor is that required. Just the fact that you were acting in concert towards an illicit end will make a conspiracy just fine. No evidence supports the theory. I don't know about that, man. Miss Kowalski was miles away when most of the conduct occurred. Fair. So plaintiff's claim was that J. Hatch intended to cause severe emotional distress by engaging in outrageous conduct outside her presence and relying on Maya or Mr. Kowalski to relay the information, so hearing the information would cause Kowalski severe emotional distress. This is a fair point. Intentional makes it hard. Like, did they have that purpose in mind? Probably not. But was it reckless disregard of a known and substantial risk? I mean, these people are supposed to be like the experts on such things, so I would think so. I mean, maybe not for a normal person. Maybe this wouldn't be reckless, but, these are supposed to be the child service experts. It's J. Hatch, don't you know? Plus, they're the professionals in the trade and so forth and so on. So, yeah. But that does not support IID. A prior court has held that IID fails in a matter of law where the defendant told plaintiff he had repeatedly harmed a young daughter for 15 years. Okay. Despite the truly outrageous conduct, the court explained it cannot allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members when there's no attendant international or reckless conduct directed towards them. Where the defendant told plaintiffs that who is he in this sentence? I'm struggling over this because this sentence is not that, I don't like this sentence because who's he? Is he the plaintiff or is he the defendant? I'm confused by the sentence's grammar. Because an avalanche of litigation would ensue where an IID plaintiff is not the direct recipient of the insult or abuse. See, that's why I'm confused. They're not the direct recipient? Hold on. The defendant told plaintiff that he had repeatedly molested their daughter for 15 years. I'm confused by this sentence. I don't know who's saying what to whom. I'm very confused. I'm going to press on. Just in the absence of sufficiently outrageous conduct is itself dispositive, the absence of intent also defeats the estate. It would by necessity. It's an essential element. The trial court found as much when ruling on J. Hatch's post-trial motion. It recognized that J. Hatch's providers, to their core, believed that Maya was not safe in the Beata's presence, yet nevertheless denied J. Hatch's motions for judgment. The estate did not prove the IID. The court should vacate the IID judgment and remand for further instructions for judgment. Okay. Well, just because, all right, that doesn't quite follow, although I appreciate your effort. Like, even assuming that the hospital and staff actually believed that Maya was not safe in the custody of the mom, right? Even if they had that belief, it doesn't necessarily follow that nothing they did was IID, because that's not the issue, right? Their belief that Maya was in danger might be their motive to act. And perhaps their motive to act was righteous in some sense, but it doesn't necessarily mean that everything they did in furtherance of that was righteous. And that's the problem, right? So the court finding, okay, even if J. Hatch believed in their heart of hearts that they were doing the right thing, it doesn't mean they did the right thing, especially insofar as they were treating Maya's mother in an outrageous way. So they could have done some things, but it doesn't necessarily excuse everything. That's the problem with that sort of conclusion. So it doesn't quite flow. All right, let's press on. J. Hatch cannot be liable for the self-deletion. This is by far and away the most interesting legal argument for me, although some of these other arguments are interesting and could potentially be a basis for something, but this is the most legally interesting for me. There's no evidence that J. Hatches engaged in outrageous conduct or intended to cause it. But even if they had stated an IID claim, the wrongful death claim still fails because they can't be liable for self-deletion. And that's sort of the bottom line of this thing. It's like, you can't get there. The overwhelming weight of authority, like pretty much all of it, holds that unless a special duty exists between the parties, and they don't have a special duty to the mother, they have a special duty to Maya because Maya is their patient, but they don't have a special duty to the mother. Their duty as a hospital is to the patient. Even by their own argument, their duty is to Maya, right? We thought that Maya was in danger. So even by their own argument, like the duty is to the patient, not to Maya's mother. So the overwhelming authority holds that unless a special duty exists, which none exists with respect to the mother, self-deletion is an independent intervening act which breaks the causal link between the conduct. Florida courts and pretty much no court, to the best of my knowledge, has spoken on this issue. Yep, that's very, very fair. J. Hatch is not asking this court to categorically bar IIAD self-deletion claims. Instead, it suggests that if Florida courts recognize such claims, they should require a more stringent standard than apply to the non-self-deletion claims. So if a person intentionally causes emotional distress while encouraging another to commit self-deletion, the IID claim could exist. Okay, that makes more sense. Although at that point, they're probably guilty of manslaughter or even murder, which is arguably exactly what happened in that case in Connecticut or Rhode Island or wherever it was, where basically exactly that happened. Remember that case, which actually led to a murder conviction or a manslaughter conviction? This girl who was dating this boy, like the boy says, I want to harm myself, I want to harm myself. And she's like, do it. And he like gets in the car and like hooks up the exhaust to the car. And it's like, I feel myself slipping away. Stay in the car, stay brave. He's like, I want to leave the car. I feel myself fading away. Stay in the car, baby. Stay in the car. Keep breathing deep. He died. And the court was like, nope. That's going to be a homicide conviction. And that one was upheld by the Supreme Court of that state. But it wasn't like enough that she was doing just generally like dickish things. She was actively encouraging and extolling him to harm himself, despite him saying, I don't want to do it. I don't want to die. And she's like, man up. It was bad. It was a horror show. It was rough. So yeah, maybe we can allow that claim to survive, but not more. Okay. I'm there. That's fine. Michelle Carter, it was bad. It was a rough case. Rough. Makes you really hate the girl. I'll tell you what, man, it makes you really, really hate her. Oof. In trial court, J. Hatch argued that for a defendant's extreme and outrageous conduct to be a legal cause of self-deletion, it must have been intended to cause the severe emotional distress and the self-deletion, and cause plaintiff to experience irresistible impulse, which I don't think there was legally, because irresistible impulse, there was too much time. She went into the garage and she, strung herself up, but that requires time and effort. That isn't, irresistible impulse, at least to me, but yeah. J. Hatch maintains that Florida should establish this high standard. Grieving families often blame someone beside the decedent. Fair. And without tight guardrails, a ruling allowing wrongful death, self-deletion liability, like claim here, could trigger an avalanche. Fair. I mean, this is by far and away the best argument for J. Hatch, because this is the argument that most appeals to me as a jurist. right? This most appeals to me as a jurist because it appeals to my conservative, small c conservative tendencies. It's like, okay, what happens next? Right? What happens next? Because it's like the slippery slope isn't so much like a fallacy in law as like the basis of law, right? We have a common law system. So what happens has very direct ripple-on effects for what's next. And we are often concerned, or at least I'm often concerned, or jurists like me are often concerned about what happens next. Where does this go? What happens next? For example, there was a kid named Ethan Crumbly, and he went to school and he did a mass shooting. And then we charged the parents with manslaughter and we convicted them. Just this one time, don't you know? And then relatively recently, there was a school shooting in Georgia. ... Yeah. So lawyers like me and jurists like me worry very much about what happens next if we allow for this. You know, this is the ultimate example, or the ultimate example of hard cases make bad law. This is exactly why that phrase exists. Hard cases make bad law. Okay? This is why that phrase exists. What happened to Maya's mother really, really sucks balls. No one is happy about it, right? No one is happy about it. And everyone's like, let justice be done on J Hatch. And people like me are like, whoa there, slow your horses down. I understand how you feel. I get it. I really, really do. But have you thought about what happens next? And the mob's over there like, what do you mean think? Mobs don't think. I'm like, I know. That's why I'm here, to help. But man, yeah. So it's like, okay, if we let this happen, what happens next? It's a pretty damn good argument for the more conservative feeling jurists. It's a pretty good argument. It's like, we're worried about what happens next. Yeah. If a claim with less rigorous standard were to exist, J Hatch suggests that only the legislature should create it, which fair enough too. Like, if we're going to do this, maybe the legislature should do it instead of the court just inventing it. You know, because, you know, maybe the court shouldn't just invent a cause of action. I mean, that's a fair argument too. Again, in our common law history, the common law is replete with judges just making up causes of action. But in more modern jurisprudence, you know, perhaps the legislature would be better. Out-of-state courts have recognized two exceptions to the general rule in which intervening act that breaks its causal chain. Where defendant's wrongful act creates a state of insanity that causes an irresistible impulse, or the intentionally tortious conduct of the defendant was a substantial cause. No evidence of either exception exists. The jury found both, but is it enough as a matter of law? The irresistible impulse exception reasons that a decedent acting in a frenzy or in the throes of an uncontrollable impulse brought about defendant's conduct engages in no new and independent act that causes causation. The person was insane when they did it, so they didn't act. So there was no intervening act. That's a pretty good argument, right? It's like you drove the person insane. They were insane. And so they didn't perform an act because they were insane. So there's no intervening act because they were insane. You've killed mens rea, and now they've killed themselves. And guess what? Now you're on the hook. That makes sense, right? No intervening act. No intervening act. The self-deletion is not an intervening act because it wasn't done by a person who was sane. That works. The delirium insanity exception is extremely limited and typically involves severe physical injury. The substantial cause exception has also been applied where defendant's intentional conduct allegedly led to the self-deletion. In those cases, plaintiffs must demonstrate that the tortfeasor, by extreme and outrageous conduct, intentionally wronged a victim, and the intentional conduct caused severe emotional distress in the victim, which is a substantial factor in bringing about the self-deletion. As argued to the trial court, a substantial factor is more likely to confuse a jury in this context than to sufficiently describe the level of causation needed for this extreme claim. Fair, because what is substantial? What does that mean? That's fair. Even applying this test, however, they fail. All right. The only evidence supporting J. Hatch's liability for Miss Kowalski's suicide was Dr. Scott Richards' counterfactual opinion testimony. Dr. Richards is plaintiff's counsel, fraternity brother, and lifelong friend. He has no specialized education and training in self-deletion and has done no research into its cause. Thank you, Iron Rabbit, for the 10 gift memberships. I appreciate it. His experience with self-deletion is limited to routine psychiatric intake questions addressing suicidality. Dr. Richards never met Mrs. Kowalski, but he testified he reviewed her personal history, past history, and familiar history, and events she may have gone through in her life to determine her state of mind at the time of her death and substantial cause. Dr. Richards told the jury that Mrs. Kowalski experienced an irresistible impulse to commit self-deletion out of altruistic surrender, which he describes as an overwhelming impulse to do something for others without any thought to yourself and even discounting any harm to yourself. He even told juries that Mrs. Kowalski was presented with Sophie's choice, nice, and made a deal with God to get Maya home in exchange for her self-deletion. He did not say that altruistic suicide is a recognized theory in psychiatry. Okay. Nor did he refer to scientific literature, studies, personal experiences with other patients, or generally accepted psychiatric techniques. Indeed, Dr. Richards failed to provide any support for his ad hoc theory. Okay. I mean, all right, maybe. I mean, we do have standards when it comes to people taking the stand who are experts, and in my humble opinion, as a general proposition, tend to apply those standards too loosely. So if they're like, well, this expert shouldn't have been allowed to testify under basically Fry or Daubert, then, you know, I'm like, okay, maybe. But the courts generally don't use the Daubert Fry flag, although they should more often, but I digress. Okay. Dr. Richards' altruistic irresistible impulse theory not only lacks support, it contradicts the evidence. Mrs. Kowalski wrote several drafts of 2 different notes, one day before the self-deletion and only minutes after the dependency court denied her request to hug Maya. In both, she stated that Maya was suffering at J. Hatch and that she contemplated the self-deletion would prompt the discharge. Self-deletion notes are perhaps the most important piece of physical evidence available to the state of mind before they took their own life. Mrs. Kowalski wrote that she can no longer take the pain of being away from Maya and being treated like a criminal. She experienced frustration watching Maya suffer in pain, while the state of Florida and the judge tied her hands. I mean, we all sympathize with her frustration, for sure. In another note, she blamed the dependency court judge for allowing J. Hatch and DCF to destroy Maya. Fair. And feared that Maya's CRPS would worsen if she stayed at J. Hatch, resulting in a slow, painful death. She directly criticized the judge's refusal to allow her to see Maya and Day a court earlier. Fair. Dr. Richards admitted that the stressors that drove Mrs. Kowalski to the self-deletion were being unable to touch her child, see her trial, the limitations of her ability to control her world, and overwhelming loss of control during child abuse investigations. Despite acknowledging that it was the dependency court judge that prohibited the hug and other physical contact between Maya and the mother, Dr. Richards insisted that J. Hatch's treatment of Maya was somehow a direct factor in the self-deletion, which I don't think that can be true. Because that's like a bridge too far. Because it counts it twice, and I'm not sure that really works. It's like it can't, if the treatment of Maya was a harm, it was a harm to Maya, right? Can it also be a harm to Maya's mother at the same time? And that feels like a bridge too far. It feels, yeah, that seems Sam. And the perception of the hospital was a substantial factor in the irresistible impulse that led to self-deletion. Fair. Even if plaintiffs acknowledge that Kowalski's suicide was not caused by J. Hatch, but by her own desire to end DCF sheltering. They argue that Mrs. Kowalski knew that she was the key. If she was in the picture, Maya was never going to get out of there. And it was likely that Maya was going to end up in some kind of foster care, in some kind of situation where they'd be even worse. In other words, she committed self-deletion because she thought it was the fastest way for Maya to return home. Which is certainly a reasonable view of at least some of her motivation. Mathis Grives for €2 said, if Jay had treated Maya fine, then no need to hug. I feel you, man. I feel you. This is rough. This is not happy fun time. Thank you for the super chat, and thank you for the gift memberships from people. We do appreciate the financial support, as always. J. Hatch was not responsible for the order sheltering Maya from Miss Kowalski. First of all, I noticed that it's now MS. I know I've been messing up, but you put it in writing. And also, you're a little bit responsible for it. You can't exactly wash your hands completely of it, man. Restricting in-person visits or denying Mrs. Kowalski request to hug Maya. Mrs. Kowalski explained her reasons for committing self-deletion, and that was a substantial clause. Okay. I do not like this argument and how it's written because it is mixing two things. Yeah, I feel like this is not just I don't really feel like this argument is well written. And I feel like this should have been broken up into two sections because I feel like it's arguing two things. The proximate cause argument, or rather proximate cause. The proximate cause argument is the more interesting, and the argument here is a little bit muddled. I'm not really sure why they wrote it this way. They're making two distinct arguments, it seems to me. But I don't know. It feels like there's a better way to raise this. Like it should be broken up into two different sections, or I don't know. Just feels could be cleaner somehow. The erroneous inclusion of the estate IID claim deprived J. Hatch of a fair trial. Fair. So, like, this was inflaming. And so if this cause of action needs to go away, then there's a pretty reasonable argument to be made that it inflamed the rest of the trial, right? Because it's like, it was a huge deal in the trial. Obviously, it's a huge deal. So it might not be possible to excise this from the rest of the trial because, well, it's inflammatory. And so if it's not legally sound, then maybe the entire trial needs to be redone. Could be. It's not an unreasonable argument. The argument that J. Hatch was responsible for the self-deletion infected the entire trial and caused J. Hatch irreparable prejudice. Jurors saw unblurred photos of Miss Kowalski's hanging corpse. That's rough. They listened to 911 calls of Mr. Kowalski and Kyle finding the body over objection. They read her self-deletion notes. Yeah, that would definitely get the attention of the jury, right? I mean, I think we can all concede. I think we can all concede, you may not like J. Hatch, but I think we can all concede that that kind of imagery would be notable in a trial. And if it was improper, might lead to problems of justice. So, they have a basis to complain. I will concede the point. They heard Maya's tearful testimony that now she wears the Christmas necklace she gave her mother shortly before her self-deletion. Maya testified that her mother wore it when she died. Maya also testified that certain colors and smell remind her of her mother, and even looking in the mirror is hard because she resembles her mother. Maya also told the jury that she replays her last phone call with her mother and wonders if there was something she could have said to save her mother's life. That's too real. She testifies she blames herself for her mother's self-deletion because her mother ended her life to get me out of there. Yeah, that's rough, man. That's rough. Kyle testified that he still hears his mother's voice and he stopped playing piano and speaking Polish after her death. He told the jury how difficult it is to live in the house where her mother committed self-deletion, and he breaks down whenever he goes into the garage. Yep. That'll do it. That will definitely do it. The undeniable emotional impact of such testimony required a completely new trial if the claim should not be tried. Fair. Fair. The beneficiary of a civil trial error has the burden of proving harmlessness, which is no reason possible the error contributed to the verdict. Plaintiffs cannot show the evidence did not affect the verdict. Indeed, the excessive verdict, which we'll maybe get to later, shows the evidence unfairly prejudiced the effect on the jury. It awarded Mr. Kowalski, Kyle, and Maya combined $108.6 million for Mrs. Kowalski's death. Who said it was $60 million earlier? Who said it was $60 million earlier when I said, oh, it was half? And said, oh, it was only $60 million. I'm like, are you sure that's the right number? Because it doesn't sound right. J. Hatch also disagrees with whoever said it was $60 million earlier. They say it awarded Mr. Kowalski, Kai, and Maya combined $108 for the death, plus $3 million for the estate. That sounds more right. That sounds more right. I think I need an apology from whoever was insisting it was 60, because I'm like, that number doesn't sound right. 108 sounds right. The trial court erred in denying the motion for summary judgment and directed verdict on Mr. Kowalski's claim for insurance fraud. All right, I'm going to skip the insurance fraud claim because I don't really care that much. All right. The trial court erred on denying a motion for directed verdict on Maya's IAD claim. Okay. Just as there's no evidence of outrageous conduct or intent to cause distress sufficient to support the IAD claim against Mrs. Kowalski, no evidence supports Maya's claim. Again, Maya must show that J. Hatch's conduct toward her was not only intended to cause distress or reckless disregard of the likelihood of emotional distress, but exceeded all possible bounds of decency. Yeah. Although plaintiffs aggressively condemn J. Hatch's conduct, they resist in clarifying what conduct was utterly intolerable to Maya. Mere medical negligence would not be extreme. True. Nor was it utterly intolerable for healthcare providers to who their core belief that Maya was unsafe in the mother's presence to detain Maya while DCF investigates. If that's all they did, then maybe, but they did some other things, man. The jury awarded $108 million, judge reduced it to 60. Okay. And having a social worker and nurse photograph a protesting child's skin condition before releasing her from the hospital is not utterly intolerable. But they said it was battery. And also, like, it can be more than one thing. So, yeah. Lacking evidence. Okay, I'm skipping the rest of this argument. Maya's EEG room was largely indistinguishable from Maya's other patient room. It was neither dark nor windowless. The video shows that while in the EEG room, Maya watched television and the children's movie Happy Feet 2. The hospital let her watch Happy Feet 2, baby. The hospital let her watch Happy Feet 2. Pack it in, boys. Pack it in, boys. That alone convinces me the hospital's in the right. They let Maya see Happy Feet 2, baby. Wow, that's an interesting detail. Okay. I don't know, man. I don't know if I would have, said that. That's okay. Played with her stuffed animals, wrote in her journal, painted with visitors, filed her nails, and ate chocolate. Are we literally doing let her eat cake? Guys, come on, dude. Read the room a little bit, man. Watch your phrasing. I don't know, man. Holy Lord. Okay, fine. It also shows her being wheeled out of the room at least twice for physical therapy. This was no dungeon. Noted. More importantly, the video shows Maya was not forced to defecate in her bed. They were trying to. She was transferred to the commode at least 4 times and declined at least 2 additional offers to be helped. The only competent testimony of her proper commode placement was that to allow the nurse to safely position herself to transfer the patient from the bed to the commode, it must not be placed against the bed. J. Hatch is entitled to a judgment of a matter of law. No, lol. but I appreciate your effort and all. No, lol. That is a very, very, very favorable characterization of the evidence that was presented on this issue. Yes, there was that kind of evidence, but there was also some other evidence that was a little bit more problematic. The evidence supporting Maya's first false imprisonment claim is insufficient. Plaintiffs claim that J. Hatch falsely imprisoned Maya during the first week of the hospital stay. There was evidence that J. Hatch obtained Maya's parents' consent. Yes, there might be. There might be evidence of that. Sure. You could argue from the evidence that they had parents' consent. Sure. I mean, they signed a form and stuff, and yeah, you could argue consent, but there was evidence to suggest they didn't consent. So, you know, when you have conflicting evidence, you know what you do? You give it to a jury, man. That's what they're for. So sure, there's some evidence. There is some evidence to support the proposition that Maya was there with the parents' consent. There is some evidence to support that proposition. The problem is there's evidence that goes the other way. And then it's up for the jury to figure out which evidence is best evidence. That's what they do. There was evidence they obtained Maya's consent for her to stay, but regardless, oh, we don't even need consent anymore. That's nice. But regardless, the conduct was both reasonable and statutorily protected. First off, proof of false imprisonment requires, among other things, an unlawful detention that's unreasonable and unwarranted under the circumstances. Fair. Given the trial court's pretrial ruling that as a matter of law, J. Hatch was reasonable to suspect Munchausen by proxy, sure, and its post-trial recognition that J. Hatch healthcare providers at J. Hatch to their core believe they really like this fact, don't they? They really like this. J. Hatch to their core believe Maya was not safe in Bieda's presence. Their action to protect Maya in her first week cannot be unreasonable and unwarranted. No. The first 24 hours, sure. You were protected by law for the first 24 hours, but not so much after that. Second, plaintiffs also cannot meet false imprisonment's requirement of element of action without legal authority. Chapter 39 authorizes healthcare providers to detain a child without consent. For 24 hours, yes, it does. And then not so much. The provider must immediately notify DCF, and if DCF determines the child should be detained, DCF must petition the court for custody within 24 hours. While the statute clearly requires DCF to act within 24 hours, it's silent on whether Florida healthcare providers must return a child to a life-threatening situation if DCF fails to act within 24 hours. Well, I mean, it would have to, because the act says what they have to do. They have to get the emergency order. And if you don't, then yeah, you have to give the child back. Maya's hospitalization from October the 7th until she's ordered shelter on the 13th is authorized. No. The first 24 hours is expressly authorized. Yes. And it's reasonable to interpret the statute as giving the licensed physician discretion not to return the child. No. Within a week of the detention, a court ordered them sheltered. Okay. Because J. Hatch's conduct was authorized? No. A new trial? No. No. They had to get the order within 24 hours. That's what the statute authorizes. After that, no. But thank you. All right, Chapter 39 immunity, wherein J. Hatch tried to have it both ways. Despite initially recognizing Chapter 39 immunity, you tried to have it both ways, J. Hatch. The trial court misinterpreted plain statutory language when recognizing only reporting immunity. The error allowed plaintiffs to do exactly what Chapter 39 prevents: seek civil liability and damages for good faith participation in a child abuse investigation and court order sheltering. No, the court didn't allow any of that. Section 39 expressly immunizes two kinds of good faith conduct: participating in any act authorized or required by Chapter 9 and reporting instances of child abuse. Chapter 39 has immunized all authorized actions since its enactment. That is the stupidest sentence I've ever read in my life. Because it's tautological. I hate this sentence because it's tautological. And I object to it because it's tautological. I don't like it, and it makes me mad. Chapter 39 has immunized all authorized actions since its enactment. Yeah, that's really great, counselor. That's just fantastic. That's fantastic. Yes, you are correct. You are correct. The Chapter 39 has in fact immunized all authorized actions since it became law. That is what laws do. That is how laws work. Yeah, the law came into effect, and then since then it's been the law, don't you know? The law's been the law since it's been the law. Wow, that's really informative. I'm just a bill, only a bill, sitting here on Capitol Hill. All right. And Chapter 39 authorizes a wide array of conduct besides reporting and including many forms of treatment. It allows CPT doctors such as Dr. Sally Smith, boo, to diagnose and evaluate patients, including performing x-rays, lab tests, and related results. Again, the problem isn't what Chapter 39 authorizes. Okay? Chapter 39, like every statute, has bounds. Okay, it has bounds. It is not a get out jail free card. Okay, it is a thing that exists within its own domain, and it provides the domain, and it is the bill, and it is what does it. It doesn't make everything you do in every context authorized. That is not how it works. And even if it allows you to do some things in some contexts, it doesn't mean you can do everything. Or it doesn't even mean you can do those things in every context, right? If you're allowed to do something for some purpose, it doesn't imply that you can do the thing for all purposes, right? It's limited in both domains. So sure, I'm quite positive the statute allows for doctors to do all kinds of exciting things. I am thrilled. I'm much more interested in what the limitations of it are. So it authorizes them to do a whole bunch of shit. I'm sure that's great. Florida courts have explained that Chapter 39 is broadly construed to encourage good faith action. In allowing litigation against DCF investigator who returned a toddler to a dangerous home where he was soon killed, the law explained that Chapter 39 immunity was not intended to protect those who failed to fulfill their duty to protect children. Instead, the broad immunity in the child protection law was intended to protect those who might be overzealous in protecting children from potential abuse. Yeah, maybe, but it doesn't mean it's without limitation on the other end. Right? So even if it, all things considered, encourages people to protect children, right? It doesn't mean you get to go infinitely far the other way. That is not how that works. It is not a blank check, ma'am. A broad interpretation is necessary to fulfill the legislature's intent. Chapter 39 immunizes even overzealous child protection efforts. Maybe, but no, I don't think so. Child protection mandates that immunization, overzealous, good faith action may cause parents great distress whenever parents view sheltering as unwarranted and evasive. But that does not give parents a cause of action against good faith actors. Chapter 39 and its broad immunities were created for the benefit of children, not for parents. Yes, broadly speaking, that's true. But you're kind of taking it to and past the breaking point. The trial court plainly misconstrued the scope of Section 39. The court held Section 39 provides immunity only for those claims that otherwise result from the report of suspected abuse. Once J. Hatch's statutory obligation report was fulfilled, the court ruled its subsequent affirmative conduct towards MK was not immune, and that's wrong. Okay. The court's failure to fully enforce 39 requires reversal. It violated reading the whole text canon, under which proper interpretation requires consideration of the entire text in view of structure and physical and logical relations of many parts. It also violated the elementary principle of statutory construction that significant effect must be given to every word, phrase, sentence, and part of a statute if possible. And words in statutes should not be construed as mere surplus. I'd like to take note that those are mutually contradictory things. Right? Which of those things am I supposed to do? Right? Am I supposed to read this in the context of everything? Or am I supposed to give every single word its full effect? All right, so those can be contradictory goals. Worse still, the trial court's ruling the act that flowed from reporting suspected child abuse was immune was enforced inconsistently because you tried to have it both ways, and the court limited the immunity to pure Chapter 39 reporting issues that no overlay with the court considered non-immunity issues. You don't get immunity for everything. When there was overlay, the court admitted evidence of immune conduct and relied on the instruction of the jury to ignore it. All right. The trial court's misinterpretation of 39 led to erroneously allow plaintiffs to argue Dr. Sally Smith was J. Hatch's apparent agent. Nice. There can be no dispute that Dr. Smith was not J. Hatch's actual agent or employee, and her conduct at CPT medical director in DCF investigation is not J. Hatch's legal responsibility, and the activity that Chapter 39 broadly protects. She was wearing a goddamn J. Hatch coat. She's wearing a J. Hatch coat, ma'am. If you did, yeah, you know, why not employee if employee shaped? Why not employee if employee shaped? She was wearing your lab coat, man. All right, let's skip this because I don't really care right now. That's fine. The trial court denied J. Hatch a fair trial. We're still on Chapter 39 immunity, so I'm going to skip this for a little while. I think we got this. Okay. Drawer instructions to ameliorate the prejudice, blah, 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 blah. All right, so let's see if we can do anything for excessive compensatory and punitive damage awards. Okay. The damages awards are excessive. The awards for past and future medical, including psychological expense, have little supporting evidence, and improper closing arguments bolster the excessive awards. Dude, guys, J. Hatch, you could have made an argument at closing arguments. You know, I'm not necessarily like opposed to the idea that plaintiff's argument is not necessarily the best way of looking at things. Like, okay, let's do it on a per hour calculation and how much is it worth per hour that leads to this really weird or excessive award. Like, I mean, I sort of get that. I understand that may not necessarily be the best thing to do. But you didn't give the jury a chance, man. You didn't give the jury a chance. You just like, you know, went up there and be like, you know, do justice. You know, you didn't give the jury any sort of numbers to work from or any sort of formulas. You didn't show them any comparables. You didn't give them anything to work with. And now you're sad because like, well, the jury had, okay, they had from plaintiffs, here is a formula to follow. We suggest you follow the formula. And from defendant, J. Hatch were like, you know, just do the right thing. You know, so you kind of blew that play. And I don't really think the Court of Appeals is going to go out of their way to bail you out. You know, I don't think they're going to go out of their way to bail you out. Claims with no basis for compensation cannot support punitives. Okay. The denial of the motion for a new trial or remitter is reviewed for abuse of discretion. There is no evidence that Maya sustained any physical injury or needed any treatment based on her first week of hospitalization. Yeah, but she was kidnapped, though. Plaintiff offered no evidence that Maya would need treatment because of the event, either before or after she turned 18. Invited to speculate, the jury awarded Mr. Kowalski $67,000 for past medical expenses and Maya $2.5 million for future medical expenses and $3 million in non-economic injury. Yeah, but you kidnapped her, though, and you didn't give the jury anything to work with. You didn't give them anything to work with. There's no evidence that Maya was injured or needed any medical treatment, past or future, because of 2 days she spent in the EEG room. But the jury awarded $561,000 for past medical expenses and Maya $1.4 from future medical and $3 million. All right, other than just reciting numbers, do you have anything else than just number big? Maybe number big, but would you like to like explain why number big or give me something else to work with, and then also why didn't you tell the jury about it? You want the Court of Appeals to save your ass for not doing your job. Yeah, As to the Jan 6 false imprisonment battery, on these counts as well, plaintiff offered no evidence of physical injury or past or future medical treatments. Yet the jury awarded $884,000 for past. Okay, I'm skipping anything until you give me something that isn't just numbers. Medical malpractice. Maya's medical malpractice award included $4.7 million for lost earnings and future medical treatment, plus $22 million in non-economic damages. J. Hatch alleged that malpractice was weaning Maya off ketamine and continuing the conservative therapies began at the general. I mean, no, that isn't the only malpractice. That isn't the only malpractice. Other was, also not giving her the psychological counseling that she was needed under your theory. And also you wouldn't pick a lane. So there's that. But no, this is where for a while J. Hatch had me confused. Because for a while I was like, oh, there's no medical malpractice. If you guys remember me covering this earlier versions of these videos, there was a time where I was like, no, I don't think there's medical malpractice here. I don't see it. Because J. Hatch had me confused. They had me focused on the wrong issue until you guys finally set me straight. I was like, oh, the problem is that they denied her ketamine. I'm like, no, I don't think that's malpractice. I don't think that works. And then you guys are like, wait, no, it doesn't matter, because if they thought it was, the disease, if they thought it was CRPS, if they did think it was CRPS, part of the treatment is psychological counseling. And if they didn't think it was CRPS, if they thought it was Munchausen by proxy, part of the treatment is psychological counseling. They didn't do psychological counseling, so now it no longer matters. Because either way, they had to do psychological counseling. Either way, they didn't do it, which means either way, it was a violation of medical standards. And either way, it was medical malpractice. So now it no longer matters which it was. Plus, there were other things beyond that, as I learned more about the case. But J. Hatch did have me confused for a while. And I don't like being tricked. So. Although plaintiffs' experts claim that J. Hatch's withdrawal of high-dose ketamine would aggravate CRPS, they also acknowledge that CRPS patients experience lifelong pain. And the evidence was, with ketamine withdrawal, Maya resumed walking. CRPS isn't that kind of disease. It's kind of an on-again, off-again kind of thing, as I understand it. So she resumed walking, exercising, bike riding, and ice skating, all while excelling at school. Wrongful death. Finally, even after remitted, the total full wrongful death award is $66 million. Okay, there you go. The trial court remitted the $50 million pain and suffering to 24 after a $250,000 remitter. Maya and her brother were each awarded $18 million for pain and suffering and $1.75 in support for services until age 25. This is all excessive and speculative. Well, it's a little speculative, but that's how the future works. We're guessing. It's not so arbitrary as to require us to do something about it. Despite being instructed not to duplicate damages, jurors award Mr. Kowalski $1.5 million for past medical expenses, an amount far higher than all of Maya's J. Hatch's bills combined, and which obviously exceeds the maximum limit of a reasonable range in which the jury may operate. That's fair. That's a fair point. That's a fair point. The award for past medical expenses is more than all the medical bills combined. I mean, that's fair. Maya's awards are even more excessive. The jury awarded her $23.7 million for future medical expenses and lost wages and $69.5 million in non-economic compensation damages. That is $6,000 every day for over 40 years. No reasonable jury could conclude the relevant evidence supports that amount. They could, because you didn't give them anything to work with. J. Hatch argues that the IID suicide claim cannot stand. If the court disagrees, the damages far exceed what a jury could reasonably award. Even after remitter, they awarded $63 million, $24 for Mr. Kowalski, and $19.75 each for Maya and Kyle. This is outside the reasonable range that a jury could operate within. The trial court abused its discretion, denying J. Hatch post-trial motions for new trials and remitter for these claims. In closing, plaintiffs, over J. Hatch's objection, showed the jury a PowerPoint that requested massive non-economic damages based on per-hour component formula. This formula allowed plaintiffs to ask for excessive and unjustified damages. J. Hatch knew plaintiffs were using the formula, and it moved in limine to exclude the argument. The trial court denied the motion shortly before closing arguments. By using why didn't you provide your own formulas or whatever? By using the formula, plaintiffs misled the jury into awarding excessive damages. For example, Mr. Kowalski requested $25 million for his pain and suffering by dividing it in two separate components, seeking 27 hourly payments of $100 per hour for a 24-hour day. So that'd be $2,700 a day. Even at the remitted judgment is more than $920,000 per year of life. Maya similarly requested 20 hourly payments of $100 for nearly 40 years. Her remitted judgment still exceeds $450,000 per year. But courts have long warned the trial court must use care to the end that the per diem argument will not inflame the jury in reaching an excessive verdict. The trial court did not use such care here, and the impassioned and inflamed jury awarded the excessive verdict. But per diem arguments are allowed, even if they have to be used with care, and also you didn't give the jury anything to work with. The trial court's denial of summary judgment and directed verdict on the self-deletion claim and its admission of immunity, combined with plaintiff's improper argument, result in awards based on passion, not law. The verdict size provides no benchmark for the court to award lesser amounts. Okay, but you need to know what the limits are, so we know what the trial court's supposed to do. So that's not great. You're also not giving the Court of Appeals a lot to work with. You're just they're really high. Okay, but what's the limits? We're not going to tell you. All right, then how are we supposed to give instructions? All right, and then the punitive damages award is excessive because reasons. The standard for granting a directed verdict in punitive is no different for other claims, but clear and convincing burden of proof requires higher quality evidence. No, it doesn't. No, the quality of the evidence, no, that's wrong. No, that's not right. Although Maya never pled her claims based on Section 768, relying instead on common law pleadings for punitive damages, evidence must first establish an employee's conduct meets the statutory damage for intentional conduct or gross negligence. Intentional misconduct requires action in the face of actual knowledge of wrongfulness. I think there's some evidence of that. Gross negligence means conduct so reckless or wanting in care it constitutes a conscious disregard or indifference. I think there's evidence of that. The evidence must also establish that the employer, in this case J. Hatch, through its employees, actively or knowingly participated in such conduct, knowingly condoned, ratified, or consented to the conduct, or engaged in conduct that constitutes gross negligence. I think there's evidence of all that. As the jury explained, a manager must be more than a mid-level employee. It's someone whose level of authority could result in acts being deemed corporate acts, which I think there's evidence to support that. Plaintiffs failed to produce clear and convincing evidence of J. Hatch's employees' intentional or grossly negligent conduct, or of J. Hatch's gross negligence. The trial court erred in submitting all four of the punitive damages claims to the jury. J. Hatch properly reported suspected abuse to DCF on the 7th and 9th. It declined to release the child against medical advice to her mother. Yeah, that's the problem. You can't do that. The mother was a nurse infusionist who wanted J. Hatch to administer massive doses of ketamine through an existing port after Dr. Hannah sent her to J. Hatch because of her condition after such infusions. I don't know if it was because of that. J. Hatch's doctors cooperated with DCF as required by law. That's not the issue. Plaintiffs failed to prove that anyone has actual knowledge of the wrongfulness of the conduct and high probability that injury or damage to the claimant would result. And they argued that doctors provide the treatment themselves were managers if they chaired hospital committees, when this court has ruled otherwise. Okay. Moving a patient to another room on the same floor is not wrongful conduct. No, that in and of itself is not, although it might depend on the room and what you did there. Only Maya's sensationalized testimony, which sounds like an issue for the jury, about defecation due to abandonment and isolation would support the claim, but the video evidence disproves this allegation. Okay, but the jury can weigh the evidence. There's certainly no clear and convincing evidence that Maya was abandoned or isolated during these 2 days, or anyone had actual knowledge of wrongfulness. While there's evidence that moving her to the room was not one employee's unilateral decision. There's no evidence that J. Hatch's management contributed to these acts. Yeah, but, conspiracy and stuff, so no. All right, skip. Even without the errors described in subsection 1 and 2, the errors remain legally excessive. The law requires that the award bear a reasonable relation to the amount of damages proved and the injury suffered. Although the ratio between compensatory and punitive damages award was not excessive, the compensation damages themselves were grossly excessive. The punitive damages cannot stand because the compensation can't stand. I like that. That's cute. I like that. It's like, well, the ratio is right, but only because the amount is off in the first place. So therefore, the whole thing is bankrupt. Cute. All right, and for all these reasons, we want this stuff. All right, so some of these arguments aren't bad. The arguments that are more at the top of the page are better, which is fair enough, right? You definitely want to lead with your best stuff. So I do appreciate them leading with their best stuff. And the issue on the underlying liability for the intentional infliction of emotional distress of the mother remains the most interesting. And it is, I think, a novel question of law. It certainly seems to be under the relevant precedent. So, I think they're right. And also, I think they're also probably right that if that is wrong, that it can't be severed out because it's so inflammatory. So, if they win on the IID claim, the odds of a new trial, I think, are pretty high. So, and there's also some arguments to be had that they didn't do things to Maya's mother that support the IID. So they've got factual claims, although I don't think they're as strong. So they've got the factual claim of we didn't do the bad thing to Maya's mother. And there's some argument to be had there that it is not, we did bad things to Maya, and we, maybe to Maya's father, but not to Maya's mother. And we need to sever those out. We need to separate those out because they're independent people with independent causes of action. I'm like, yeah, that makes sense. And so maybe there's not enough here factually, although that seems a bit harder to get to. But, maybe it's not like a frivolous argument. It's actually kind of interesting, but it might work. But I don't think it's probably the most likely basis, right? The Court of Appeals tends to look for the argument that's the easiest to win, right? Because it's like, they want to make their lives as easy as possible, just like anyone else. So, that there's not enough here that towards Maya's mother is an idea, but the underlying issue of, okay, we need to change the standard, or we need to elevate the standard, and you need to show actually that they were trying to cause her, their motive and their intent was to commit the self-deletion. So it's not enough that it led to it. You need to actually show that they were trying to accomplish that objective, which I'm not really sure that they can prove that. I don't think they can prove that. I don't think Maya's parents or Maya and her father can prove that J. Hatch was trying to get Maya's mother off themselves. So that by far and away is the most interesting, is the causation argument. So the factual argument's interesting, probably doesn't work because, you don't necessarily want to rule against the jury. But the legal issue of causation is interesting. And so, we'll see it'll be interesting to see what Maya says in reply to that, to be interesting, because it'll be interesting to see what they think is their best legal argument. I don't think they have a lot to work with. Although that being said, there's just not a lot of recognition for this cause of action. And so I think J. Hatch's idea of if we're going to do this, it needs to be explicit that we were trying to cause the suicide. That was our goal. It's not enough that we caused pain generally. We were trying to get them to delete herself. That makes more sense. And then it's now a wrongful death cause of action. And maybe that's all that's left. Maybe it's a wrongful death cause of action. Instead of maybe it's a wrongful death instead of an IAD cause of action. And it would be criminal because it would be manslaughter or murder, as we learned from that one case in New England. So it'll be interesting to see what Maya's attorneys have in reply and what they have to work with, because I don't know if they necessarily have a lot to work with. Their best argument is the outrage of it. that this situation is outrageous and the whole thing is fucked up. And, so there must be justice. Their best argument is there must be justice. But, the more conservative jurists, the people like me, are like, well, we got to be sure that while giving you justice, we don't fuck everything else up completely. Right? We got to be sure that while giving you justice, we're not fucking everything else up completely. And the caution and alarm bells are going off in my mind huge with this kind of thing. I'm like, I don't know, man. I don't know. So like, yeah, I'm sympathetic to Jay Hatch's argument on this one because I am very deeply concerned. I'm very deeply concerned about recognizing this in its full fat form and what happens next. So, yeah. And then if they're right about that thing, that's like, that maybe a new trial is required in order to prove that, assuming it can be done, which I'm not sure it can, but back to new trial. If it can be done, it's like reverse and remand, with, you need to find this as to allow this evidence in. Yeah, maybe. So I think the odds of a new trial aren't horrible. Jay Hatch has definitely got some ideas. All right, so I'll take a few questions or a few comments, and then we'll wrap the stream up because that was fun. And then I'm going to make some roast beef in my oven, which will be exciting. Let's see as I go to the live. Jay Hatch's money to pay for a whole new trial. Might as well pay what they owe to Maya and the family. A new trial will be a lot cheaper. A new trial will be cheaper by far. Let's see. Yeah, Sandy has been a member for 21 months. Sandy gifted 10 gift memberships. Thank you very much. Tony P gifted 10 gift memberships. Thank you very much. Iron Rabbit became an uncivilian and gifted 10 gift memberships. Thank you very much. And Mathis Grease, €2 said, if Jay Hatch treated Maya fine, then no need to hug. Maybe. What do they owe Maya at this point? A little over $200 million. Plus interest, arguably. Watch them have to pay double the current judgment? Maybe. Yeah, the Court of Appeals forces Jay Hatch to turn over the documents they always had but never turned over. That's pretty funny, Benjamin. Yeah, that's pretty funny. Yeah. That they played dirty is definitely something I'd want to highlight as Maya's lawyers in my response. I definitely want to be like, these guys played dirty. They didn't give us information. They defied court orders and all the rest of it. Because you don't want to make the judge pissed off. And if I can make the judge pissed off that counsel fucked around with the trial court, then I might be able to get them to focus just on that issue and rule for me just because they're pissed, or at least inclined to rule for me because they're pissed. Well, we weren't sure which way we were going to go, and then we learned you dicked around with the trial court, and now we're pissed, and so we're more inclined to rule for you. So I definitely want to play into that. Yeah. Mama Betts has been a member for 14 months. If the appellate court agrees with the mother, cause of death being a separate issue, does the entire case get retried? It depends on whether or not it's salvageable or not, right? It's not an automatic, right? So it depends if it can be severed. Is it severable as a matter of practice? Can we excise the wrongful death and all its attendant effects from the trial? Can we pull it out as a separate segment? And that's a practical consideration. And Jay Hatch is a pretty solid argument. The answer to the question is no, right? Because this is so inflammatory. The jury saw pictures of the mother's corpse hanging in the garage, okay? It's that's pretty inflammatory shit, right? So it's like, well, hey, we can just pull the whole thing out. Harmless error, no big deal, right? So I think Jay Hatch is a pretty solid argument that a retrial would be required. So it's not automatic. It depends whether or not the Court of Appeals and really ultimately the Supreme Court of the state, because I feel like there's no way this doesn't get appealed either way to the Supreme Court now. I don't feel like there's either way it doesn't get appealed now. So it depends whether or not they feel like it's severable or not. And I'm like, yeah, there's a pretty good argument it's not. Shannon Law Nerd has been a member for 8 months. We're going to try to be covering this trial this week about the law professor who was murdered in Florida. I think jury selection begins on Wednesday. And so we're going to probably pick it up on Thursday and try to do some live streams. So we might be doing some live stream trials again pretty soon. Plus, of course, we've got Sarah Boone coming up relatively soon, so that's exciting. The audio is crackling for you sometimes. The audio is crackling. There's audio problems. Do I have to go chase down audio issues? Is it crackling again? Do I have to chase down audio issues? There is? Great. That's good. That's great news. Fantastic. Fucking great. It's just been the last 5 minutes. Well, 5 minutes is unacceptable. Let's see if that fixes it. Donna Adelson starts tomorrow. Yeah, so we'll pick it up. We'll pick it up when they start arguing. Let me know if that fixes the audio issue. And if it doesn't, then I'm going to beat something to death with a hammer. Did it fix it or did it not fix it? Seems good. Okay. Yeah. I don't know why that happens sometimes with my interface. Sometimes it just doesn't want to play nice. Audio fixed. I might try to switch out the USB-C cable. I doubt it's the issue, but I might as well try to do something. I think I've got a brand new USB-C cable in a box. I think I'll switch it out and see if that fixes the problem. Yeah, all right. Yeah, I think I've got a new USB-C cable in my tub of electronics. So I think I'll just switch out the USB-C cable and call it a day. All right. Well, I guess I'm going to go ahead and sign off now because it looks like we're good. So, yeah. Thanks for tuning in. It's been fun. Hope you enjoyed this segment, and it should be interesting to see what happens. It'll be interesting to see what Maya's reply looks like. So we'll try to keep our eye on the docket. So if you happen to see Maya's team file a reply, let me know. And, I don't necessarily cover it immediately because we might be doing other things, but I'll try to cover it, as time will allow. By the way, Shana? Okay. Hi, Shana. If they lose, they appeal Florida Supreme Court. I think either way this goes to the Florida Supreme Court. Yeah, I think either way this goes to the Florida Supreme Court. Yeah. I don't see how it doesn't. And I think the odds of the Florida Supreme Court taking it are pretty high. So my expectation is we're going to the Florida Supreme Court. Yeah. No matter what happens. But of course, you still have to go through the Court of Appeals to get there. So, yeah. All right, I'm going to change out this USB-C cable and see what happens. I've been Uncivil Law. Until later, my friends, I hope